Good afternoon, everyone. Welcome to our latest edition of Association Matters. We appreciate all of you attending today. I'd like to start by first introducing myself. I'm Marita Butzbach, the Executive Vice President of Property Management Operations for Lang Management Company. With me today is Lisa Littman. Lisa Littman is the Regional Vice President of Property Management Operations, and Rosa Hanadel, who is assisting us in the seminar today. We also have with us Kay Bender and Rembaum. I'd like to thank Jeff Rembaum and Alan Schwartzseid for being a part of this today. We hope you all enjoy this collections, liens, foreclosure, and FinCen update. We did take questions from everyone ahead of time that we'll get to at the end of this. But I want to stress that there's no legal advice that's going to be given today from either one of the attorneys for your individual associations. And you may hear them refer to it throughout, that there are times where you need to reach out for your own individual attorney. And at the end, we'll be taking some questions that are related to the seminar topic today. So thank you again for joining. And at this point, Jeff, I'm going to turn it over to you.
Sure. Thank you very much. So my role today is to provide a brief overview of the collection process as it plays itself out. So we'll start with a collection policy. So let's assume we have a member of the association who has not paid assessments. Question is, for how long have they not paid them? We're going to go more into detail later on the collection policies. But at the end of the day, you want to treat all of the owners the same. Given what I'm about to tell you, I would take a pretty hard, fast position that after somebody has not paid 30 days, after they have received one or two nice communications from the association, be it hopefully from the management company, that at that point, you go to the next stage, which is the relatively new requirement in the law, the notice of late assessment, that we all refer to as NOLA, notice of late assessment. Makes sense. Here, the legislature decided that the owners deserve one more final opportunity to pay without incurring any attorney's fees whatsoever. So this is typically not done by the attorney. What we do is, for those of our clients that need it, we prepare a step-by-step process and all of the forms and give those to the association and its management company to follow as a base guide. But that really needs to be done at the association level. Then you have to wait 30 days. Now, on that notice of late assessment, you might want to include all sorts of different items, but really, the law provides you're going to include the maintenance due, which we can only assume, instead of using the word assessment, they used maintenance, but we'll go with the fact they're talking about the assessment due, late fee, and interest. That's what we're going to put on the notice of late assessment. Then let's assume those 30 days go by. We're now going to turn it over to the attorney. So management company then prints out a ledger that goes back to the last time the owner was current, whatever paperwork the law firm may require, an authorization to proceed, an authorization to commence, along with all other communications to the owner regarding the overdue assessments. Then the attorney can prepare what's referred to as a notice of intent to lien. Here, the owner is being told, hey, this is what you owe. If you don't settle up with the association and pay in full within 45 days, then the association can take the next step, which would be to actually record the lien. So the 45-day notice, the very first one, is notice of intent to lien. You have 45 days to pay. On the 46th day, technically speaking, not that it ever works out that way, but 46th day, the association can then record its lien. Take a copy of that lien, send it to the owner, let them know this is going to be the second notice, the notice of intent to foreclose. The owner gets the copy of the lien, and it basically, again, statutory compliant letter, et cetera, and so forth. Not going to bore you with our back office part of it, but essentially it says, hey, if you don't settle up, Association's going to foreclose not sooner than 45 days from the date of this letter without further notice. And that's it. Now we're off and running. Oftentimes, the lien is very specific in terms of it secures the unpaid assessments, the interest, the late fees, the attorney's fees and costs. You're not supposed to put everything else on the lien, but that can come in later when we have more conversation and what can actually show up in the lawsuit itself. But the lien has very technical requirements. The condominium lien is good for 1 year. An HOA lien is good for 5 years. So what that means is if the condo association doesn't begin to foreclose within 1 year, the lien goes stale. It's expired. It's no good anymore. So arguably, you may have to start that process over. It's really going to depend on your counsel. But let's go back and look at some timing of all of this as all together. We have the 30-day notice of late assessment. We have two 45-day notices, the intent to lien, the intent to foreclose. That takes us to 90 days. So 90 plus the 30 for the notice of late assessment. We have 120 days. Now let's add time for mailing and communications with the attorney. Let's add time for the management company who receives the request from their association to send out the notice of late assessment. Doesn't happen that day. It's going to be a couple days. So there's always these, I would say at least another 30 days built into this 120 statutory time frame on a good day. So now you're looking at 150 days from the time you get the process started until the time you can actually file and be in court. It's almost a half a year. It's just shy of a half a year. So if you're waiting 90, 120 days to start the collection process with the notice of late assessment letter, you're really missing the boat because you really need to start the process sooner. All right, so that is just a nice overview of the collection foreclosure process. Now, different law firms handle collection foreclosures differently. At K. Bender Rembaum, we are, by the way, for those of you that don't know us, we're in Pompano, Palm Beach Gardens, Tampa. My partner, Alan, is in our Orlando office, and all we do is dedicate our practice to representation of Florida's community associations. About 22 lawyers, and this is all we do day in and day out. We have two different retainer agreements. One is for general matters. One is for collection foreclosure. You can do collection foreclosure under the general, but why would you when the collection foreclosure process we offer, we delay the billing, we advance fees and costs. We have an online collection program, so you never have to call, hey, Jeff, what's going on with my collection or my foreclosure? It's all posted for the managers and board members, login and password through our website, kbrlegal.com, and you know what's going on with the collection foreclosure. If you see me doing this with my hands, it's because I'm absolutely freezing. Just drank my lunch, a cold shake, and it's cold where I am. So freezing at the moment on this otherwise gorgeous day outside. All right, Marita. So that takes us through a good overview of the collection foreclosure process, some of the benefits some of the law firms offer, such as ours we just talked about as well. Now, back to you for some individual questions. I know that we had all kinds of readers put in questions, and we can really start
So
getting
Jeff,
into
can
the
you hear me?
nitty-gritty.
Okay, you can hear me now? Great.
Can you hear me
Okay.
now?
Yes. So some of the questions, and I know, Lisa, we got a slew of questions that I'm going to pull some of those to the beginning process because the board asked, and you touched on it a little bit. Is there a recommendation on what they should use for when they should turn this over to the attorney? I've always said to them that shorter is better because I don't think the longer you go with an owner, the better that it gets if they're not financially paying their maintenance assessment. But we had a question on, is there a guideline of what they might use as their template for a board in turning it over to the attorney?
It would be nice if there was something in the legislation on this, but we'll take a practical perspective. Declaration typically says assessments are due on the first day of the month. Oftentimes it will say they're considered late as of the 10th. So that provides like a 10-day grace for the owner to pay. Let's assume they haven't paid by the 11th. Now interest can accrue all the way back to the 1st, but so fine. We're now on day 11. At our association, yes, I'm a fellow board member as well. We basically allow the It's due on the 1st, it's late on the 10th. By the 15th, we want the management company, as part of our policy, to send out the first nice letter and then wait 15 days, send the second one, and then it goes to the attorney. Lots of different ways to slice and dice. Alan, what do you like on that?
I agree with sooner is better. I mean, the concern I have, and Marita kind of touched on it, the longer you wait, it's not making it easier for them to pay. You're not just giving them an opportunity to make this right. Most of the time, if they're not paying on time, there's a reason for it. And the longer you wait, the harder it makes it for people to catch up. So my perspective is, Jeff, similar to what you stated. And when I prepare a collection policy for a client, I put the same thing in there. It's delinquent after whatever time frame is in the declaration. If it's not paid on time, the first letter goes out. That's usually going to be one courtesy notice, so that, yeah, you might avoid that first pre-suit notice, that notice of late assessment. But if within, I'd say no longer than 30 days, maybe go to 60 for some communities, especially if it's quarterly. I would not go longer than that before you send that notice of late assessment, and I would not give it any more time before you either turn it over to counsel, or if management happens to be the one that sends that intent to lien. There's really no reason to delay this, because the reality is the thing that we're talking about today are the assessments, which is how the association pays its bills. So people that are not paying are putting the association in a position, depending on what kind of bad debt line item you've got in your budget, of maybe not being able to pay its bills at all. So my perspective is very similar. Faster is better.
What are your thoughts on some of our associations have eliminated or delayed the first notice? So the first notice, like let's say it's due on the 10th, the 15th, they get the NOLA letter.
No
Okay,
problem
sure.
on my
So
end.
you're just
Friendly.
going faster.
Yeah. Then after they still send out the reminder, but they have that on the books,
I love that. As
If-
from our perspective, I think that's wonderful. The association is saving quite a bit of time by taking that approach.
Yeah, if you're going to do it, the only suggestion I'll make is maybe as soon as it goes delinquent, maybe on the 10th, or I'm sorry, on the 2nd or the 3rd, you send out that initial notice, and then notice of late assessment goes out when it's actually considered delinquent. But there's really no requirement. As Jeff mentioned, this is just a courtesy saying, hey, we're just going to be nice and remind you before we send you a formal notice. So I have no problem with going immediately to that notice of late assessment right when it becomes delinquent.
Yeah, it's been very effective. One of the other questions they had was, when should interest and late fees be charged if the documents are silent?
When it's past due is my answer. If there's nothing specifying when you get to charge those amounts, you can charge them as soon as that payment is not made when it was due. So presumably on the 2nd is the date that can start accruing. Now, keep in mind, you don't have the right to automatically charge late fees unless your governing documents say you have that right. So a lot of communities, and not you guys necessarily, but some management firms I've seen charging late fees that are not allowed, or in the amounts that are more than the statute allows. So that's something to be careful about. But to answer the question, on the 2nd is when I would say, if nothing else says you have to wait, why wait?
Perfect. Thank you.
Marita, I see
Marita,
you.
Marita, we don't hear
again.
you. We
Can you
see
hear me
you.
now?
Yeah.
Is that better?
Yeah.
Can you hear me
Yeah.
now?
Yeah.
Okay,
Can
the
you
next
talk a
question
little
was,
louder?
should the associations make any changes to their documents regarding enforcement of the foreclosures? And can the docs include language that ensures that the costs associated are the owner's responsibility?
Well, luckily, the legislation, Chapter 7, 18, 19, and 20, all provide language that we can fall back on that allow just that, but we certainly prefer to also see it in the Declaration of Covenants as well. And I haven't seen a Declaration of Covenants that doesn't provide for that in quite some time. How
And
about
my
you, Alan?
suggestion is, if it's not already there, wait until you're already working on an amendment, add that into the package of what you're working on, and make it a separate item that the members get to vote to adopt. But I agree with Jeff. The statute already says the association. So let me step back. This is not like covenant enforcement, where you don't have that automatic right to recover your fees and costs. As soon as you sent that notice of intent to file a claim of lien, you've got the right to recover your fees and costs, presuming there was nothing wrong with the assessment process and all that. If as long as you win, you get your fees and costs back. And this is not where you get your judgment and you have to try and go collect on that judgment. The process that I guess we'll get into in a few minutes, but the process includes actually foreclosing on that lien, eliminating the owner's interest in that residence, whether it's a unit, a lot, whatever it may be. So you're going to either get the property or get your money back is the reality if you're able to complete that process.
And I like the word that you used there, process, because we have general assessments, we have special assessments, and sometimes we have monies spent on maintenance that can be converted into an assessment. So if we have general assessments, remember the burden of proof in a foreclosure is always on the association. All the owner has to do is say, Judge, they didn't do it right. They didn't pass the assessment correctly. That immediately shifts the burden to the association to prove it was done right. So special assessment. Minimum statutorily 14 days notice. But what if the declaration says you need a 30-day notice? Well, you better comply with that 30-day notice. Do we have the meeting notice that was posted? Do we have the affidavit of mailing from the manager? Do we have everything already? And you'll see at our firm, if we're going into a foreclosure, then we want all of that so that our foreclosure attorney has it at their fingertips, basically, when they're going into court. Now, let's talk about maybe the association has a right of self-help. It exercised it. It occurred an expenditure, and it wants to charge it against the owner. There's two types of language that could be in the declaration. One says it is an assessment. Well, now you have a good argument that those monies spent can be considered, for lack of a better word, an individual assessment against the owner or individual special assessment against the owner. Other times there's language that says it may be considered an assessment. Well, gosh, if it says that, that means that those monies expended are not assessed yet. You have to convert it to an assessment. How do you do that? There's nothing in the law that says how you convert that. So we came up with a process over time where essentially you're going to treat that individual assessment like a special assessment. You're going to follow the documents, and if the documents are silent, you're going to provide that owner a 14-day notice and you're going to post it. You don't have to provide it to the entirety of the community, just to the individual that you are going to be creating that individual special assessment, and follow the same special assessment procedures so that if there's any argument that the money wasn't actually turned into an assessment, it's been done. Obviously, if you're in that situation, the attorney for the association would spend more time with the board and manager counseling and giving you the guidance you need to actually do that.
And just to clarify one statement you made earlier, because it was accurate, but you said that we want that special assessment information when we're getting ready to foreclose. My experience has been we want that up front. So as soon as we're going to send out a demand saying someone owes us money for a special assessment, we want to know that it was properly adopted before the association gets into any attorney's fees, where, you know, if we close that matter out, we don't want the association responsible for any of those fees and not be able to collect it back from the owner. So we're going to make sure that we did it right, that the association followed the proper procedure before we even try and collect that money for you.
So let me jump in real quick. So one of the questions was, how does an association go about collecting on a violation whose association used self-help to ensure the property maintenance? That's what you're saying. We should be giving 14-day notice to the homeowner.
Well, no, it's very document specific. So let's assume we have to, you know, for the purpose of your hypothetical, we have to assume the governing documents say that the monies expended by the association can be converted into an assessment or are an assessment. Because if not, then it's not going to be part of this process at all. And you're going into circuit civil or small claims court, depending on the amount of money that was spent to do your collection for those monies. So it could actually go part of the collection foreclosure, or it could be separate.
And the other thing I've seen along the same lines is, and I've worked on several of these amendments where, yes, I just said that the fees and costs incurred in enforcement other than self-help are usually not recoverable in the same way. Well, you can amend your governing documents so that they are. In other words, you spend fees and costs in enforcing your covenants, and after certain threshold events occur, either the owner cures the violation or you get your judgment, not for dollars, but saying, hey, the association prevails in this case, those fees and costs get converted into an assessment. Either, like Jeff mentioned, automatically or by virtue of having that separate special assessment meeting pertaining to this particular lot or unit. So it works the same way, but not insofar as, well, you got to have that in your documents. So that's similar, but not going out and curing the violation. This is where you're actually sending out all kinds of notices, filing a lawsuit, and hopefully obtaining what's called an injunction against the owner, forcing them to fix the problem.
And since we're talking about that, I'm going to go slightly off our subject, just ever so slightly for a moment, because I really want to talk about that self-help remedy. The third DCA, about a year ago, came out with a new case, and it said, the judge basically said, before I can use my equitable powers, you have to exhaust your legal remedies. So if we have a contract, and the contract has, in a contract, the declaration at the end of the day, it is a contract. It's a contract between the owner and the association. And many of them say the association may enter the lot to cure the deficiency. And the ordinary person would think, well, gosh, that's a permissive right, not a mandatory right, because it says we may do it. So we can decide we want to or not. And if we don't want to, well, then we can go to court and get an injunction. Well, the court said, I'm surprised it took this long for a court in Florida to actually recognize this. In the old days, we had two different courtrooms. One was for a court of law, one was for a court of equity. You had a breach of contract problem, you went to see the judge that was dealing with those issues. And then if you had an equitable problem, judge, tell them to do it because it's the right thing to do. That was a different courtroom. Well, we merged those together in the United States a long time ago. But the principle still exists that you must exhaust the legal remedies before you can exhaust the equitable, before you can get to the equitable in the first place. So if your documents say that you may enter the lot to cure the deficiency, before you can go to the court to ask the court for an injunction to tell them to judge, paint the house the right color, you first have to try to exercise that right as the association, if your documents have that permissive language. Lately, when we're amending and restating governing documents, this becomes a very big subject for the board, because do you want to include that permissive right of self-help or not? Because if you have the permissive right, you may do it. It really means you must do it, or at least try, before you go into court and ask the court for the injunction. So that's a big change. Just wanted to bring that up since we were talking about it.
We have association they do have the rights to do the self-help, but that's very helpful to know going forward, because it's been a big question on a lot of boards, because they're in situations where people are just not taking care of what they need to do and want to know what avenues they have to go to do it.
Right, and this becomes a big part of the conversation. It's also helpful if the association doesn't want to exercise the right of self-help, tells the owner they're going to do it, and the owner then comes up with something like, I'm going to, I hate to say it this way, if you step on my property, I'm going to file a lawsuit. If you step on my property, I'm going to do this, I'm going to do that. Well, now we can go to court and say, well, judge, we tried to exercise the right, but we got stymied. So therefore, we're coming to court to see you for an injunction.
And the other thing that we are working on for a lot of communities is, frankly, just amending the documents to eliminate the right to perform that self-help, except the items that we carve out that you're willing to go onto someone's lot and do. For example, you don't want to have the general right to perform self-help for any violation, because personally, I don't want my clients' vendors going on someone's roof to replace it.
Exactly.
So that's just one example that I use frequently, because the reality is it's something you're never going to want to do. Okay, I don't care how bad that roof is. You're not sending someone out onto that roof. Jeff was a little more, I guess, courteous than I'll be. You don't want someone shooting through my vendor's foot on that roof, is the way that I'll put it, or knocking the ladder down so they can't get off. I've seen one of those events happen. I won't tell you which, but that was here in Central Florida. And the bottom line is, you just don't want to create those issues for the association, its vendors, etc. So a lot of people are just amending that self-help language out, with carve-outs remaining for going onto the lot and mowing the lawn, weeding, edging, things of that nature.
Thank you.
Marita, we don't hear you if you're speaking. I'm not sure what's happening over there. Well, you look like you're speaking eloquently and quite profound, but
Okay. I can help you with the next question, Marita.
Thank you.
Should the associations make any changes to their documents regarding enforcement of foreclosures, and can the docs include language that ensures costs associated are the owner's responsibility?
Well, I think Jeff covered a lot of that. One change I would make, if you don't have the right to charge the maximum interest and late fees that are authorized in the Florida statutes, which is 18% per year for interest. And for the late fees, it's 5% of the installment or $25, whichever is greater. If you're going to make changes, those are the ones I would make. But again, as Jeff mentioned, if you don't already have the attorney's fees automatically accruing, all of these things in your governing documents, it might be something to add. But the reality is, for the most part, it's not necessary because the statutes will cover it.
The other question is, how long should the association wait to foreclose on a property? This is a big one. We've been getting a lot of questions on this lately.
well,
None days.
I
wouldn't
agree
wait
with
at
what
all.
Alan said there. You want to move it as quickly as you can because we have 120 statutory days, let alone time just to be human beings, because everything doesn't happen right the very next day. So you're really looking at 150 days from the time you start with the notice of late assessment till the time you can get this into foreclosure and file your action. So with that in mind, do you really want to wait 60 days before you send the notice of late assessment?
No.
And as we mentioned earlier, you're talking about waiting 60 days. Even if you wait 30, you're talking about 6 months from the start of this process going delinquent until you actually just filed your foreclosure action.
And
then
Alan, how
you've
long
got
does
the
it take
time
to
to
get
actually go through the lawsuit.
right? And how long does that take?
I would say on the short end, it's 6 months.
There you go. So minimally 6 months, and I've seen them go much longer, obviously.
Right.
So minimally 6 months.
So what is the lender's responsibility on this part of a foreclosure?
The lender,
Yeah, let's say
well,
that.
they are superior to us. So if for whatever reason a member is paying their mortgage but not paying the association, then the association can still foreclose. But when it's all said and done, whoever ends up entitled to the property, they're still subject. They don't have to pay the mortgage, but the lender can come in and foreclose their interest out at any time. So you're taking the unit subject to that first mortgage. I hope everybody that made sense. So I've had situations where associations foreclose, they end up with the unit because there was no real value to it because that first mortgage was still sitting out there and it was superior. Association ends up entitled and essentially leases the property once they own it for less than market rate with full disclosures. There's still a first mortgage on this property. Lender can come in and foreclose. You may have to move out with less than 30 days notice, da 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 da. So that the lessee is on full notice of the situation. But I think there was a question too about when an association can lease the unit, right?
Exactly.
And so here's
Yes.
one. We just came up with one example, but you just can't lease the unit out because you're in the collection foreclosure. You need to own the unit, with the rare exception of asking the judge to appoint a receivership over the unit, and then the receiver could possibly lease the unit out, which is very different than a delinquent owner who has a tenant. And remember, the association has the right to direct the tenant to pay their rent to the association. And if not, then the association can take action against the tenant and against the owner.
So if an association forecloses on a unit, let's say, there is a bank, they have the foreclosure, and they're able to lease it. A lot of their questions come with who's responsible for the property taxes and the
Who owns it right now?
Hmm?
In your little example, who has title? Who has what we call fee
So the
simple?
bank has the title and the association has
If the
foreclosed.
bank has the title, bank is responsible to pay the taxes.
So they would
Whoever
pay
the
the
title
lender.
holder is.
Interesting.
And that wipes everybody out, by the way. If you want to carry this forward, if the property taxes are not paid, it will eventually wipe out the first mortgage. It will wipe out any back due assessments.
Now,
Then-
Another
Mhm.
situation I've seen pop up, and by the way, make sure your attorney is the one preparing that lease or at least an addendum to the lease if the association owns it. We want to make sure to get that protective language that Jeff mentioned into that lease. And frankly, your realtor is not going to necessarily be capable of that. But moving on to what we're talking about now, the opposite situation also happens where the lender is foreclosing, the association finished its foreclosure action, the association doesn't want to be a landlord and they just want to get rid of it. There are investors who will come in and buy these properties for a relatively low dollar figure, usually around what the association was owed and not fair market value, but they'll buy it and then they'll work with the lender to try and take care of the mortgage rather than be foreclosed. So there are investors out there that you can bring in. And, the way that I've worked it out with some of them is they have the obligation during the entire pendency of before they work things out with the lender to make sure that the assessments are paid on a monthly basis, to make sure that the property is taken care of. And if they don't, then the association has some kind of expedited foreclosure remedy against them. And in exchange, they will pay either all or most of what the association was owed. So you're getting everything you were owed back, even though you didn't have a third party purchaser at the foreclosure sale in the association case. So you're getting most of what you needed, but you've got someone in there who's paying and taking care of the property going forward, rather than taking on the obligations, the risk, etc., that we're mentioning now with respect to leasing to somebody else. So that is another option after the association forecloses, even if the lender is foreclosing already. If they're not, I agree, rent it out for as long as you can, or sell it for fair market value and pay the lender off at closing.
Thank
You all
you.
hear me now?
Yeah, we can.
Yes.
All
Oh,
right, you're
you can hear
back.
me.
You're
Oh,
Yay.
wonderful. Sorry. Yeah. So issues with my laptop. I apologize for that. Sometimes I think my kids would love to have a off switch button, just like my laptop gives me. Yeah. So one of the questions that we had that came through was if a unit owner defaults on a settlement agreement from delinquent assessments, do we need to start the 30-day notice and the late assessment period before having the association's counsel reinstate the collection efforts?
Not if you did it right.
depends. Not if we did it. Right. If we did the settlement agreement, correct, because we want the owner to basically say that if they don't honor the agreement, they're rolling over at that point. So we can enter basically a judgment against them for the foreclosure and go back into court and move things rather expeditiously.
Yeah. So the shorter answer is no, you wouldn't be starting over if it was done correctly, meaning if we prepared it.
One of the other questions we had at the very beginning, when I wasn't able to speak, was one of the owners out there asked, why can't they just start the process on day one if that's when the assessment is due? So if it's due January 1st and they don't pay and they know it was due, why can't they start with their late letter that day? Do they have to have any grace?
Do they have language in the declaration that says it's due on the 1st, but late on the 10th?
They would have to change that. Then that's what you would
Right,
recommend. that they
because
do.
then you wouldn't want to start on the 2nd,
Right.
right? You'd want to wait until you get to the 10th and then start on the 11th. But yes, you can start that quickly depending on what's in your documents. Here's something that happens. We saw this quite a bit years ago, and we still see it today. Sometimes the declaration will say and have language in it, essentially, in the event of a foreclosure, whoever ends up in title, a third-party purchaser, if you will, doesn't have to pay anything, which is in direct contrast to what's in Chapter 720 regarding, and 718 regarding what a purchaser at a foreclosure owes, which would be all the back due assessments, right? But we're not talking about the lender, the first mortgagee here. We're just talking about Joe Schmo who ends up going to the foreclosure sale and ends up entitled to the unit. What do they owe? Well, we want to say they owe everything, right? Jointly and severally for all the prior monies due. But if your declaration has language in it that gives the purchaser a full pass, chances are the court's going to go with the language that is in those documents, most especially because of some cases that have gone through the court system. Alan, I'm talking about Pudlet and that whole progeny there. So you need to check your governing documents. And if you have that language that gives a third-party purchaser a pass on the past due assessments, you really want to amend that out.
And the same applies to giving the lender a free pass.
Yeah.
The statute says that the lender would owe the lesser of 12 months of unpaid assessments or 1% of the original mortgage amount. Some declarations say the lender doesn't owe anything if they foreclose and take title. So those are different issues that your attorney should probably take a look at, and the board can decide whether you want to propose a change. And then the other issue that the attorney will have to get involved in is, does the lender have a right to object to that kind of amendment? Do you make it effective for only mortgages that are taken out after the date the amendment is effective, which is the way that I tend to do that?
One of the other questions we had is, I'm excited that you can all hear me. Can a condo owner be banned from common areas and amenities for failure to pay their condo fees?
After
I'll
following
be
a
there.
process, generally, yes. But that process entails 2 meetings and notices and a bunch of other things. It also requires that the amount delinquent be a specific amount. I think it's $1,000 and at least 90 days delinquent is what's in the statute.
For a suspension of use rights. And then
Right.
it would be done, it's been a while since I looked at that, but it's done at the board level. It doesn't have to go to
Correct.
the fining committee. It's all done at the board level. It's a simpler, faster process, but still you need the compliance with the legislation to do that. But you
Correct.
certainly can, turn off the clubhouse card, the entry card, if you will.
Like the
Can't use
fob.
the clubhouse, can't use the amenities anymore. But you have to follow the process. But notice has to be provided the correct way to the owner that this is happening. So you will need consultation with the association's attorney to do that. But it is an effective tool on occasion. In my association, however, our amenity is a gate out front. Oh, we can't stop somebody from coming to their property. So we really have no use rights to suspend anyway.
That's the other thing
So
to
it really
consider. There
depends
are
on the association.
limitations on what you can and can't suspend. You can't tell someone you can't park in your parking spot. You can't tell someone you can't use the condominium elevator, things of that nature. So just be aware that there are limitations to what you can suspend, as Jeff mentioned. But yes, the procedure is fairly straightforward, but there are requirements, especially in a condo, that it be a certain dollar figure and a certain time frame. In an HOA, those limitations don't exist.
What we've
And I
done
feel
in
like
some of
we
the,
live in a world where it's like I after E,
Am I gone
except
again?
after C. Sorry?
You're good.
no, I thought I was
Oh.
going again. In what
Thank-
we've done in some of the HOA and master association is they take away their rights to use their transponder. So they have to go through the security gate to
Right.
gain entrance into the community. And in some of the associations, they've actually had it so if they call in a guest, they have to go greet the guest. Their guest
Go get 'em.
cannot just
Hmm.
correct.
And what about taking away the voting right because of the delinquent assessment? That's another tool.
Mhm.
But there are a whole bunch of hoops that you have to go through. And once again, we have an I after E except after C, right? The association law is full of traps for the unwary, right? You just don't know this stuff. It's not written in a book. It's not written in legislation. And if you're not practicing in this area on a daily basis, you're liable to miss out on some of these things. So here we have yet another court holding where the law said we could suspend greater than 90 days. You haven't paid your assessments, you can suspend your voting right. Here the court said, well, gosh, if you didn't have that language in your declaration, you didn't have any Kaufman language, this declaration is subject to Chapter 720 as amended from time to time, then could you really take away that sacrosanct voting right? And the court said, no, you could not, interestingly enough. So
That De Soleil?
what's that?
Is that De Soleil? The De Soleil case? Is that what you're talking
Oh,
about?
I'm not sure the title of the case.
All right, let's just say I'm right for now then.
Sure. And our prior case we talked about was Pudlet. Yeah, I think it was De Soleil.
I'm going to go to the other spectrum of collection issues. What are the restrictions relating to a board member speaking to parties of a bankruptcy proceeding?
Speaking to parties, I'm not sure I understand the question, but if we have a hint of bankruptcy, it stops us as the lawyers cold in our tracks.
Mhm.
A hint of bankruptcy. So do I need to receive a piece of paper from the bankruptcy court? No. Just about any kind of notice that this person has met with and is doing the bankruptcy, we're done, right? We can't
No
take the chance of
conversation.
violating federal court orders and such. So what was the actual question in there? Can we talk to who?
It says, what are restrictions relating to a board speaking to the parties of a bankruptcy proceeding?
I never have a problem with parties talking directly with each other. You have a plaintiff, you have a defendant. They can talk to each other. That doesn't mean the lawyer can talk to the defendant or vice versa, right? The lawyer on the other side. But parties can always talk to each other.
So Jeff, if the president or the treasurer wanted to speak with an owner who was in bankruptcy, you feel that they could do that?
I think they probably could talk to them.
I think
But there
that
are issues involved there as well once an owner goes into bankruptcy in terms of what the options are. You're going to need to involve the owner's bankruptcy attorney relatively quickly, because as soon as they have that conversation between I can't even imagine what they would talk about, because essentially, I can't imagine what they would have to talk about.
No, because it wouldn't be a payment
Yeah.
plan.
I mean,
Right.
the reality is that bankruptcy is such a structured statutory process that there's really nothing to discuss. I mean, if the owner wanted a payment plan, they could have reached out beforehand. If they want one afterwards, it's going to have to be approved by the bankruptcy court. If they're in Chapter 13 bankruptcy, the entire purpose of that bankruptcy is a payment plan for 3 to 5 years. And I am always cautious about board members speaking with owners even before the account gets sent over to counsel, because the likelihood of a he said, she said, where the owner claims that they were given some kind of beneficial terms that never were discussed in the history of the world is increasingly frequent. So my concern would be, if an owner's in bankruptcy, your attorney gets involved and your attorney speaks with their bankruptcy counsel if there's
That's the
any
better way.
communication outside of the court proceedings.
Yeah, definitely the better way, what Alan just said, for the attorneys to talk. So the board member really can take the position, hey, we're in litigation with you. You are in bankruptcy. It doesn't have to be just the bankruptcy. It could just be that litigation. Let the attorneys do their job. So if there's a message that needs to be relayed, there's no reason why the attorney can't relay the message to the owner's attorney and handle it that way.
On the payment plan section, we have a question that says, as a manager, and this does come up too, even when it's turned over to a legal, as a manager, should I accept a payment for an owner who received a 30 days collection letter and who submitted a payment plan for board approval? So
Well,
here's my payment.
if somebody makes a partial payment, I'm going to start there. Someone makes a partial payment. Short story is, again, case law, right? But you have to take that money. Now, even if they give it to them, this is where it can get a little dicey. Let's say we have them in collection and they offer the money to the management company and the management company sends them away. That can be a problem in the foreclosure once that gets to the court's attention. The better practice would be accept the money and immediately get it over to the attorney. The check itself, the form of payment, get it to the attorney so the money gets applied properly in that litigation case. But if you were to send the debtor away, even if it's a partial payment, that can be a problem later.
So if the manager takes their proposed payment plan.
No, I didn't say that. I didn't say take the payment plan. I only talked about money.
So we don't take the plan. We just say, look, we're going to take the check, but we're not going to take the payment plan. We're not going to bring it to the board.
You can do both.
Bring it to the board's attention.
What you can do is say, yes, we'll offer you a payment plan, and that'll be one of the payments that gets applied toward the payment plan, or we'll base the payment plan on your new balance after applying this payment. There's no reason you can't do both.
Perfect.
Marita, we don't hear you again. Yeah. So what else do we have for questions that came in live? Can association president use money to pay for their personal vendetta against homeowners? I have no idea what that one means. Can the association president use community money? Well, no, you can't use, as a board member, money for personal reasons of any type. So let's just start there. Everybody needs to be treated the same. All the debtors need to be treated the same. Alan, you're
You guys
welcome
hear me
to jump
now?
in.
Yes.
Oh, yeah, that was
Oh,
just buying
great.
time for you.
So
I'm
Jeff,
with you,
one of the
Jeff.
other questions, thank you. One of the other questions that came in was if they want to collect the money directly from a renter and they're delinquent on their assessments, what was the process?
Oh, the process is we send a letter to both the owner and to the tenant. To the tenant, we say, you are hereby directed, we quote the Florida law, and you need to send your rent payments to the association. And if you don't, you're subject to eviction. To the owner, we send a letter and we tell him what what the association's statutory right is, and we tell him if he interferes in that process, right,
So
that
question for
there'll be
you.
a problem.
So if the renter comes back and says, because we actually had this happen in an instance that they prepaid
Yeah.
their assessments, do
Well,
we have
okay, I
the
get that,
authority
right?
to
Yeah, I
ask them?
prepaid, right? I prepaid, so therefore I don't owe any money at all. Well, you could take the position, fine, if we don't believe the veracity of the person, we think they're lying, then we simply say, tell it to the judge and start the eviction proceedings. Now, prove to the court you paid that money in advance.
And those costs for those proceedings, that's all collectible from the owner of the property?
The statute isn't really clear on that.
I'm not,
I've
I was
made
going to
the
say, I'm not
argument that it's
100% clear.
I've made the argument that when you file your foreclosure, that was a cost incurred in collection because you wouldn't have done it but for the delinquency on the account. The
Mhm.
other thing that you need to do is actually win that eviction case. So
Right.
as Jeff mentioned, if we're not really sure and we find out, no, this guy really did make a payment, he paid the full year in advance and that rent was paid and they weren't fabricating this. Well, then you might lose that eviction case. So it's not like in the collection context where it's automatic recovery. Now, that doesn't mean that you can't simply put those fees and costs on the ledger, but whether a judge goes ahead and awards them or says, no, I'm going to eliminate this part of the collection, you get everything else, that's going to be a case by case analysis by the judge.
Okay. And Lisa, it seems like when I go to the Q&A for the question is when everybody's losing me. So if you want to pull a few more from, I was trying to pull the ones that
Got
people were
it.
texting in because there's a bunch in the Q&A.
Oh, I got the vendetta one. Hold on. Are the attorney's fees added into the final special assessment being assigned to a delinquent account?
So they're
Yes.
collectible as part of the collection process. Go ahead, Jeff.
Oh, there's an issue that can arise. It needs to be, those monies must be referenced in the complaint itself. If you were to have a special assessment that occurred during the pendency and it didn't get paid, all right, so during the pendency of the collection proceedings, the board passed a special assessment and it didn't find its way to the ledger before we started the legal action. If you then include the monies in the final court order, it is problematic. You needed to go back and amend the complaint to include those special assessment funds. Yet another trap for the unwary. This is, again, not defined in the law. You learn it the hard way.
Right.
So
And I was looking at the question as more, are you able to collect your fees and costs as part of the collection matter? The answer to that question is generally yes, presuming you win. But they automatically get included as soon as you send that notice of intent to file a claim of lien. They're included. The judge can reduce them before a judgment is entered. If you are going to resolve the matter before that judgment is entered, you can put all of them in.
I also want to address, can we use the owner's name at a board meeting, the delinquent owner? Can we identify them by name? I don't see any need to do that. We have two different bodies of law. We have the Federal Fair Debt Collection Practice Act, and us attorneys, we're subject to that. The association is not, because you are essentially owed the money, and managers, for the most part, are not subject to the Fair Debt Collection Practice Act, though we don't know if that pendulum will ever change. So caution there, all managers. And then we have what's it, Alan, the Florida Consumer
Collection
Practices Act, where you cannot go out of your way to unduly harass or embarrass a debtor. So why would you want to leave the association open to a counterclaim during the collection foreclosure process? You mentioned my name at the board meeting for the sole purpose of embarrassing me in front of the membership. So why not refer to it at our board meetings? We don't refer to them by owner name, lot 32 or 10239, the address of the property. But we try not to use the owner's name itself.
Jeff, before we jump to the FinCen portion of this, can you hear me okay?
Yeah.
Barely. You're asking about FinCen.
Yes, before we jump to that, one of the questions that we are asked by many owners is, what, if anything, is the state doing at this point for the classes that they are required to take, the 4 hours continuing education?
Yeah.
Some of them think that they're really out there and we're not sending
Right.
them.
No,
That's
here's
my
what's going on.
understanding. So if you could address that.
The classes. Great question. I wish I had concrete answers, but I can tell you where we are, right? Board members. Condominium board members, you have to be recertified, okay? You have to be recertified by June 30th, 2025 in the new 4-hour condominium board cert class, even if you were previously certified. You have 1 hour of continuing education a year as a requirement. HOA board members, assuming you have less than 2,500 parcels, you are required to take 4 hours of continuing education, and your board certification is good for 4 years. But for 4 years from when? And that would be 4 years from when that requirement came out that the board cert's only good for 4 years, which is June. The law came out July 1st, 2024. So you have until June 30th, 2028 before HOA board members have to be recertified. All right. Now you have the 4-hour continuing education course. But how can you be required to take the course when the DBPR has not yet certified, as far as I know, to anybody yet, the topics available, for that, we'll call it CEU credit or Community Association board member credit, whatever name they come up with for it. So we're still in a state of flux on that. I just haven't heard yet. Alan, how about you?
I'm in the same boat. I spoke with several people. There was a trade show for an industry group, CAI, last week here in Central Florida. I spoke with 6 different attorneys who routinely teach these types of classes for board members. And frankly, no one has been approved that I've heard of. I've heard of one class for 1 hour that's been approved, and it was not clear from my discussion with the person that it's actually being approved for this particular purpose.
Gotcha.
So I have a feeling that it's approved for CEU for managers, but not for board members. So
right.
My brief answer is I agree. I'm not aware of anyone that's been approved to teach these particular, I call them the extracurricular or the optional classes. Although they're not optional, they're more of an elective as to which class you take.
And I'll add to this conversation that condominium board members now, to be certified, have to both take the 4-hour class and sign the 8.5 by 11 piece of paper. They read the governing documents, will abide by them, they'll faithfully discharge their duties. Oddly enough, in the HOA Act for homeowner association board members, the ability to be certified in any way by signing that 8.5 by 11 is completely removed from the legislation.
With that, we've had homeowners.
Yell, Marita, you have to yell. Can't hear you.
Can you hear me now?
Yeah, talk louder.
Okay, can you hear me now?
Yes.
And I usually have the loudest voice in the room, so there you go. So FinCen, the topic of the hour for almost
boy,
a
oh
year
boy.
now.
We've heard interesting, a little tidbit, right? Little legal tidbit. I'm going to address the FinCen question, but we did have a judge who had to enter a ruling, a district court judge. There was a Chamber of Commerce. And in that litigation, the Chamber of Commerce, on behalf of all of its members, sued United States Department of Treasury, FinCen, for all different arguments as to why these regulations regarding the registration of the beneficial owners, et cetera, unconstitutional, this reason and that. And the court said, I'm going to issue an injunction, but the injunction is only good for the plaintiffs. In other words, the 28,000 members of that Chamber of Commerce. Why? Because the district court recognized it did not have the power to issue a nationwide injunction. That case just came out 6 months ago, a year ago. Compare that against what we're hearing in the news about all these district court judges issuing injunctions, right, nationwide. adverse to the executive powers of the Constitution. It's just fascinating to see that we had a case on that subject that just came out a year ago, and now we have this whole other panel of district court judges taking an opposite position than that judge did. So that in this context, the judge said, I don't have the power to issue a nationwide injunction. And in the other context, the district courts are saying they do. So it definitely will have to be decided by the United States Supreme Court. But that has nothing to do, I digress. That has nothing to do with your question, which is a good one. And I'm going to short track it right to the end game. FinCen and its infinite wisdom, after going back and forth, it's due, it's not due. It's going to be due by the end of, what was it, December 31st, 2024. But if you had a hurricane, blah, 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 then in Florida, it was good until you had until June 30th or something to do it. However, no United States domiciled companies are subject to the requirement anymore. It is only going to be for foreign companies that have to complete the registration of beneficial owners. So if you're like me and already did it, well, you did it. Done, over, no continuing requirements, but you did it. So what? Okay, do you have to do it if you didn't do it? Community associations, and the answer is at the present time, no.
Thank you.
You're
Because I
welcome.
think a lot of it, can you hear me now? Am I talking
Yeah.
loud enough?
You're
Yeah,
good.
yeah, but you still got to keep talking, very loud.
Loud.
Your
Okay,
gain is
got
just
it, got
really
it.
weird.
Sorry, and I'm sorry about the technical difficulties today. Lisa, do you see any other questions out there at this point?
There's a couple still in there. One
Sure,
of
go
them
ahead.
says, can the unit owner do the work on their own and make the association reimburse them?
For what?
Evidently something they feel should be fixed.
Well, it doesn't sound like it's a collection foreclosure matter, and those analyses can get very, very complicated. So we would need a whole lot more facts to be able to have a conversation on that one.
What about an abandoned property with a reverse mortgage that is a larger than the property value? What recourse does the condo board have?
Well, if you want to get a dues paying member in there, the only way to do it, because the person with the reverse mortgage, the company, you've already explained they're upside down in the deal. They're not going to get their money back. Best thing the association could do would be to foreclose, get it, the title and the name of the association or somebody else. But then if we get it, then it can be rented. The property can be rented subject to one of those disclosure deals first, the reverse mortgage people could come in if they're holding the first mortgage at that time.
Yeah, there's always a lot of questions about the reverse mortgages in our other associations. Interest, can it be charged on late fees?
No.
Only if you want to get your clock
Alan,
clean.
no.
Don't do it.
So here's the better answer, kind of. And the short answer is no, but the way that the statute applies all of your payments that are received by the association is first to interest, then to late fees, then to attorney's fees and costs. Actually, it says cost and reasonable attorney's fees, and then to the assessment, which means that the short answer is kind of, because everything that remains due might be qualified as an assessment until all of the assessments are paid. So depending
However,
on how that payment gets applied, you can charge the interest only on the assessments. Whether what's still due is an assessment or not depends on that calculation.
I'm going to make it much easier for everyone to understand. Do not charge interest on your ledgers. Only on the
Thank you.
assessment.
Correct.
That's the final words of wisdom for today, right?
Yeah.
Do not charge interest on your
Your
interest.
interest.
Right. Do not charge interest on late fees. Do not charge late fees on late fees.
So
Noted.
Jeff and Alan, I really want to thank you again for being a part of this for all the owners out there today. We appreciate it. Lisa,
It's
thanks
fun.
for your feedback today. There is a small questions at the end and a little survey. If you could please make sure at the end of this, just look for that. It was sent out to all of you by Kay Bender and Rembaum, and we appreciate all of you attending today.
We want to know, we're doing this for you, for all of you that are out there, and we graciously thank you for attending. But we want to know for our next course, which is going to be what? We're doing 4 of these a year? Is that where we're at?
Correct.
Once a quarter?
Yes.
We
Correct.
want to hear from our people that are attending. What do you want us to talk about?
Mhm.
Please be sure to fill out that survey as Marita requests.
We hope you found this educational for all of you and really appreciate you taking the time to be with us today. Thank you.